They are just a methodology. Mergers are generally happening a lot of small states to the next door state or union of state which they formed. That has nothing to do with. Now, some states have accepted the Constitution of India, some may not have said so. That's once you sign, that's the last. You become integral part of India. With this adaptation order before the Indian states, the rulers signed the instrument of accession. So therefore, every state which signed, so far as it's becoming an integral part of India. And in fairness, Mr. Sibal concedes not that JK is fully integral from that point of time. But it has consequences. So when Article 1 talks about merger of territory, when it talks about including the state, it is not just off the cuff. That's the mandate flowing from the statute, accepted by everybody. Everybody is acceding on that basis. So it's an understanding. Therefore, all these states are mentioned in the schedule. And their territory is incorporated. That's the integrity. And the instrument is at page yes. That is at PDF 350, which your lordships have seen in the other volumes. Lordship may just note that in the very beginning it says, Dominion of India established by the India Independence Act shall, as from 15th August, be a union of, that's the first clause is the amended draft. Section 5. And please see C, 5C, Indian states acceding to the dominion in the manner hereinafter provided. So if you accede in the manner under section 6, you become part of the union. This is also there in volume 6, PDF 103. And 6A says, if you declare that he accedes to the dominion with the intent that the Governor General, Dominion Legislature, Federal Court, other dominion authority established for the purpose of dominion shall, by virtue of instrument, but subject to the terms thereof, and for the purpose of the dominion, be vested in the order under this act. So once you accept all these authorities, once you integrate, how do you integrate if you don't accept? And the terms, the expression subject to terms doesn't mean that you, these are minor modifications or qualifications which may come in, but you can't say that on the one hand that I accept the Supreme Court, I accept the President, I accept everything, but qualification, I will not accept 136. So therefore, my lords, my submission is that our independence is not a grant of India Independence Act. We had already resolved to form a republic, a sovereign independent republic. And 3, we amended the adaptation orders to make it clear to all the rulers of the states that the moment you sign the instrument, you are part of the union, you are integral. So
actually, if you see the constitution, the provisional constitution order of 1947,
yes,
which is a part of Mr. Arvind Datar's second edition of 2007.
Yes, I will
find it here at page 348. Page 348.
Yes, Manoj.
And what it says is that, the Government of India Act shall apply with such modifications as are specified in the schedule
Yes.
right? And if you go to the schedule now at page 350,
Yes,
there you will find the modification of section 5.
that's right.
The Dominion of India established by the Indian Independence Act shall, as from the 15th of August 1947, be a union comprising of C. The Indian states acceding to the Dominion in the manner hereinafter provided.
That expression is very important, in the manner.
In the manner. And now 6 says accession of Indian states.
Yes.
An Indian state shall be deemed to have acceded to the dominion of the governor if the Governor General has signified his acceptance of an instrument of accession executed by the ruler, whereby the ruler on behalf of the state A declares that he accedes to the dominion with the intent that the Governor General, the Dominion Legislature, the Federal Court,
Yes.
and any other dominion authority established for the purpose of the dominion shall, by virtue of this instrument of accession, but subject always to the terms thereof, and for the purposes only of the dominion, exercise in relation to such states such functions as may be vested in them by or under the Act. Assumes the obligation of ensuring that due effect is given within the state to the provisions of this Act, so far as they are applicable therein by virtue of the instrument of accession.
Now, B completely destroys the argument of internal sovereignty. You have to give effect to all these authorities, the laws made, the execution done, the judgments given within the state. Reservation of some subjects, my lord, doesn't mean that some sovereignty remains. That's a distribution of powers only. So you have some more powers which others.
What do you make out of that statement in the IOA where the Maharaja said that I have retained my sovereignty for the future?
You see, section 6, which is amended, does not contain any such term. Maharajas cannot, as the learned Solicitor General showed, somebody is saying that we will have reservation about tax. So that's their wish. You may wish anything. But so far as the statute is concerned, as adapted, section 6 does not contain any clause 8. All that remains is that by supplementary instruments, you can further make more concessions. You may concede more subject matters. That clause 8 is completely beyond 6. It has no validity. But I will say, you read that clause 8 of IOA where Hari Singh says, I preserve my sovereignty. That is only meaning that he is preserving his power to legislate and do whatever with respect to the remaining subject matters.
Okay. What's the next point, Mr. Mr. Dwivedi? We'll have to leave some time today for Mr. Giri. So long as all of you are within the time framework, we have no problem.
But our time should be up till Monday, at least.
Monday afternoon, Monday lunch.
So we'll try to finish by that. It won't.
Monday lunch is the final time.
Ordinary may not be a spill at all, but
we were hoping that
the learned council have agreed that I must.
Monday afternoon we have to, so that then we can give them the rest of Monday and Tuesday to complete the rejoinder.
We'll. So we'll, as I said, we'll try to.
Mr. Dwivedi, can we do this? We are 12:05. We can give you 10 more minutes. And then Mr. Giri, 45 minutes till through lunch, and we wrap up.
We'll finish by 12 minutes instead of stopping Mr. Giri,
No, but
we'll finish.
Primarily now, the main council are to follow you, Mr. Giri, Mr. Mahesh Jetmanani, and Guru. Right?
So
the others, look. One second, don't interrupt. I'm in charge of the proceedings. We have to, these are the 3 seniors. Now, after this, we'll have a lot of interveners, etc. But what is to be said has been pretty much said. We will request all the interveners to please talk to the council who are following Mr. Datar. Whatever they have to say, they may indicate to the council who are now going to argue, so that the 4 council will cover the entire gamut. I think that would be a very fair way of doing it. And then we'll hear the interveners for 2 minutes or 3 minutes.
That's right.
So please, 1 second. This is now a procedural, this is a procedural mandate now, which is that all interveners who are going to follow will talk to Mr. Giri, Mr. Jetmalani, and Mr. Guru. And whatever you have to say, please tell them to say it on your behalf. They will not be charging a separate set of fees, and we will conclude with that. I think that's the only way. Now, tell us, Mr. Dwivedi, how long now?
We'll finish, our side will finish by lunch, Lord. The Lordship is, because otherwise, Lord,
all right. Do we take that, that between Mr. Giri, Mr. Jetlani, and Guru, you have bifurcated the time with Mr. Dwivedi? Do we take it so that you're finishing by lunch on Monday?
On Monday?
Yes. So,
just that
whatever remains, one second, whatever remains after Mr. Jetlani, Mr. Giri, and Mr. Guru Krishna Kumar have completed, we are here to hear you until lunch, but we will not hear the respondents after lunch. Fair enough. We have no difficulty. After we've given you the names of people who are going to argue. After they have finished, if there's some time remaining before lunch on Monday, we will hear you certainly. But after lunch, that's it. At 2 o'clock, we call upon Mr. Sibal to start the time. Oh, I'm so sorry. Nothing now. We have to now. We'll have the whole country wanting to argue here, but now that's all right. That's all right. That's all right. You sit with the seniors who are arguing after. There has to be some order. You can sit with the seniors during the course of the weekend, and you can talk to them. If somebody has a point, please tell them. Yes.
let me
adhering to what your lordships have indicated.
Absolutely.
Right.
Can the interveners circulate a short note?
No difficulty. Absolutely. A page at the most.
because
Lord, some of them have taken a lot of invested a lot of time and passion.
But of course, we don't deny that. But then presentation has to be through either the seniors who are arguing have to curb themselves, or then we have to just do what we have to do.
We'll abide by the timelines that your lordships have indicated.
kindly just note the documents. I will not read now because of the time constraint. Your Lordship may look into it. Just at PDF 328. This is about the paramountcy. What was the view of the leaders on the Indian side when they were discussing? None of these Indian states were independent, really.
Mr. Dwivedi, we have understood this argument.
Yes. I'm not reading therefore. I'm just saying, Lord, Your Lordship may note the first is Raja Gopalacharya's note. The second note, Lord, is at page PDF 331, which is Sri Alladi Krishna Swami Iyer, Lord. And they took lot of pains and the last note is of Pandit Nehru himself, Lord, at 339. To Lord Ismay, who was the Chief of Staff of Mountbatten. All three of them, they were persisting that they have never been independent. What are you doing? This return of this paramountcy was an attempt to balkanize India, create so many enclaves, and that created so much problem. And it is thanks to Sardar Patel's Lord that all this was quick. And when he left, he was wondering, my Lord, that what he was trying to negotiate on 3 subjects. And Sardar Patel, he said that you have wiped out the monarchy from the map of India. So therefore, my Lord, they were hardly independent. And we know from Amritsar Treaty, my Lord, on the basis of an amount of money and 1 horse and 12 shawls, etc., which is mentioned in the next document, I will not read it. It was transferred to Gulab Singh, and that's how this. So when were they earlier under Ranjit Singh and some king or the other? They were never independent. So that's the. So therefore, this sovereignty flowing internal residuary, whatever, there was no sovereignty. And whatever left, Article 1 finishes. That's the complete merger. No merger agreement is required. No supplementary instrument of accession is required. Now, my lords, in re Berubari, kindly read, I am reading only from this para 73 of my written submission, which is at page 298. Has it?
Yes.
Now kindly come to PDF 299. The bold portion. Cession of national territory in law amounts to the transfer of sovereignty over the said territory by the owner state in favor of another state. There can be no doubt that such cession is possible, and indeed history presents several examples of such transfer of sovereignty. It is true, as Oppenheim has observed, that hardship is involved in the fact that in all cases of cession, the inhabitants of the territory who remain lose their old citizenship and are handed over to a new sovereign, whether they like it or not. And he has pointed out that it may be possible to mitigate this hardship by stipulating an option to emigrate with such certain period in favor of the inhabitants of ceded territory as means of averting the charge of the inhabitants are handed over to new sovereign against their will. But though, from the human point of view, great hardship is inevitably involved in cession of territory by one country to another, there can be no doubt that a sovereign state can exercise its right to cede a part of its territory to a foreign state. This power, it may be added, is of course subject to limitations which the constitution of the state may either expressly or necessary implication impose in that behalf. In other words, the question as to how treaties can be made by sovereign state in regard to cession of national territory and how treaties can, when made, can be implemented would be governed by the provisions of the constitution. Stated broadly, the treaty-making power would have to be exercised in the manner contemplated by the constitution is subject to limitations imposed by it. Whether the treaty can be made implemented by ordinary legislation, constitutional amendment will naturally depend on the provisions of the constitution. Then, kindly come to the next overleaf, my lords. Last few lines of this paragraph. We have already referred to Article 1(3)(c), and we have observed that it does not purport to confer power on India to acquire territories. It merely provides for and recognizes automatic absorption or assimilation into territory of territories which may be acquired by India by virtue of its inherent power as a sovereign state. So that 1(c) and 2, they are straightaway act of state. So even Constitution can recognize by its provisions certain powers which are in the nature of act of state. It may circumscribe it or it may not circumscribe it. Now kindly also have 74 Santosh Gupta, my lords. This was read out by Mr. Nafre, but he said this is obiter. State of JK has no vestige. This is two judgment. State of JK has no vestige of sovereignty outside the Constitution of India and its own constitution, which is subordinate to the COI, Constitution of India. It is therefore wholly incorrect to describe it as being sovereign in the sense of its residents constituting a separate and distinct class for themselves. Residents of JK, we need to remind the High Court, are first and foremost citizens of India. Now, this is not obiter. I have explained in 75. My lords will look into that. There were direct questions in the High Court judgment. It was said, my lord, that JK is sovereign, and therefore their lordships dealt with it and said that that sovereignty is not there. It had lost its sovereignty. Then I have quoted the speeches, my lords, from Shri Nehru, my lords, and Dr. Ambedkar in para 76, 77, 78. Your lordship may just note, my lord, each of them are saying that, I may just read 76. Shri Jawaharlal Nehru said, we accepted it, and of course the accession was complete. It was not a kind of partial accession or limited accession. The accession was complete. but we said that we will abide by the verdict of the people whenever the chance or the opportunity comes. He also said, so Kashmir obviously is a constituent unit of the Federation of the Union of India. But a difference has subsequently arisen, you please remember that, not originally, between Kashmir and the other states, because subsequent to the earlier accession, the other states have become integrated more, which Kashmir was not and could not in the circumstances, as I have tried to point out. But nevertheless, it is a whole constituent unit of India. Various things flow from it, various consequences. Consequences, for instance, in regard to the President of the Republic, but the President's ultimate right has to remain for a constituent unit of India. So various consequences, I already spelled out what follows from the integration and unionization. And Dr. Ambedkar also said, this has been read by the learned Solicitor General, let me just note. He explained what is meant by union. And kindly turn to next page, Manoj. I'm not relying so much, I've quoted though Rajaram Pal, which says destructible units and all. Maybe some lines need to be drawn. It can't mean that all the states disappear and federalism disappears. So that was your lordship's worry also when the learned solicitor was arguing about Article 3. Then para 80, the state of West Bengal versus Union. It expressly says that the feature of a compact or agreement between independent and sovereign units are absent in the Constitution of India. There is distribution of powers, but distribution of powers is not always an index of political sovereignty.
Where is this? Oh yes, para 80.
I'm reading from what I have said, but this is part of the judgment. Para 25 I mentioned. The lordship may note that. In para 80. Then kindly have paragraph 51 going back a little. Para 51. That is PDF 293. Same written submission. Yes, Manoj, I am sorry, Manoj. Is this para 25 of state of West Bengal is fully quoted, Manoj, beginning at PDF 291. And your lordship will find the relevant portion in clause A. Okay. Kindly come to PDF 292. PDF 292. This is a paragraph 25. From fourth line, the result was a constitution which was not true to any tradition pattern of federation. There is no warrant for the assumption that the provinces were sovereign, autonomous units which had parted with such power as they considered reasonable or proper for enabling the central.
Where? Page 291. PDF page.
PDF 292.
291 it starts.
Yes, it starts in 291.
There is no warrant for the assumption?
Yes. There is no warrant for the assumption that provinces were sovereign, autonomous units which had parted with such power as they considered reasonable or proper for enabling the central government to function for common good. The legal theory of the constitution was the withdrawal of resumption of all powers of sovereignty into the people of this country and the distribution of these powers, save those withheld from both the union and the states by reason of provisions of part 3 between the union and the states. A truly federal form of government envisages a compact or agreement between the independent and sovereign states to surrender partially their authority in their common interest and vesting it in the union and retaining the residue of the authority in the constituent units. Ordinarily, each constituent unit has its separate constitution by which it is governed in all matters except those surrendered to the union. And the constitution of the union primarily operates upon the administration of the units. Our constitution was not the result of such compact or agreement. units constituting a unitary state which are non-sovereign were transformed by abdication of power into a union. Then the second characteristics is supremacy of the constitution which cannot be altered except by the component units. Then C, distribution of powers between union and regional units. If your lordship, the fourth is supreme authority of courts to interpret the constitution, that is D. Kindly come below that. In our constitution, characteristic D is to be found in full force. A and B are absent. There is undoubtedly distribution of powers between the union and the states in matter legislative and executive. But distribution of powers is not always an index of political sovereignty. So this theory, which bilateralism, compact and all this objective resolution was unilateral, adaptation was unilateral, Article 1 is unilateral, 370 is unilateral. So there is some exchange of thoughts and agreements to be within the fold of 370 does not make it bilateral. So bilateralism need not be introduced in 373. Kindly have para 51 next page. Even in a pre-constitution setting in Pramod Chandra Deb versus State of Odisha, para 17, a constitution bench of this court held that sovereignty of erstwhile ruler ends with cession of territory. And when this court said some sovereignty is retained after the execution of IOs, that was a passing reference as sovereignty was being discussed in the light of an old grant of land by ruler to son. Such grant would amount to law which was continued post 1948. So the rights under the said grant were recognized by the new sovereign power. And Indri Beruvari also takes the same view in para 31, which I had already read. So cession of territory is a very vital and Article 1 therefore declares the end of, if any doubts remain, that's the last nail in the coffin of sovereignty. And it is surprising, Lord, that my friends on the right, Lord, wedded to democracy are seeking permanence based on a crown which is long gone. The king is dead, long live the king. The Lord should just note, Lord, in para 69, just even anger, Shri Anger also says that they are fully integrated. We can't extract some paragraphs here and there, Lord, and assert based on 2 paragraphs what is the meaning of our clause 1, 2, and 3. Page 26. If you shall come in that paragraph stated next page, that is 298, PDF 298. The draft Article 306A was placed before the Constituent Assembly on 1710 and passed on the same day. The Anger said the meaning of accession is that at present day, the state JK unit is a unit of a federal state, that is Dominion of India. Dominion is getting transformed into a republic, which will be inaugurated on 26th. JK state therefore has to become a unit of the new Republic of India. He goes on to say that instruments of accession will be a thing of the past in the new constitution. The states have been integrated with the federal republic in such a manner that they do not have to exceed or execute a document of accession for the purpose of becoming units of the republic, but they are mentioned in the constitution itself. Now all this is left out and you extract 3 paragraphs where he is trying to say very lightly about referring to clause 1, 2, and 3. And he doesn't say what happens after the JK Constitution Assembly ceases. He could not have said, the times were so difficult. Therefore, it is a very brief speech. But these are much more vital expressions in his speech. You don't have to exceed or execute a document of accession for the purpose of becoming units. The preamble and Article 1 and 5 and fundamental rights, all they complete. That's the republic. Without it, there is no republic. So, my lords, that's in my dispute submission, my lord. My submission with regard to this. I don't wish to, my lord, add anything about 356, etc., my lord, except to say that, not in Bommai's case, there are two observations with regard to the width of this suspending power. Paragraph 271 and 281. I'll give it in a piece of paper, my lords, the paragraphs without detaining your lordships. 56 invocation will be in variety of situations which cannot be in variegated situations. So therefore, what will be the circumstances, emergency, provision, or will depend. So I just wanted to point out to supplement, Lord, those paragraphs which I'll give. And one more thing, Lord, that's a Constitution Review Committee was constituted under the chairmanship of Venkat Chilaya, my lords. And 356 was an issue whether it should be retained, or he said this is the bulwark of the Constitution. So the concept changes, my lord, with time. Initially, it was thought it will never be exercised, but the review committee says, and a very high-level committee, Justice Jeevan Reddy was also a member of that committee. And they say that is a bulwark, but yes, there has been some abuse. Therefore, the checks and balances, my lord, the adjudicatory powers, the judicial review is there to check it. So with this, I, my lord, conclude and say, my lord, that let us bury 370. 35A, my lord, I'll just... my friend has filed a writ petition also questioning, my lord, 35A. So I just wanted to give, my lords, your lordship, which again I'll mention, my lord, in the piece of paper, the paragraphs of IR Kolho, where your lordships have held that this, if you come out with any instrument of law, with constitutional amendment, which that was in the context of 31B, Vaman Rao and in Minerva Mill and all those were considered, and the lordships have held, my lord, that if all laws which are placed in 31B will be tested. And so far as certain, of course, prospective overruling, etc., is a different concept. But here we are finding that 35A has been super added. It's a complete lock, stock denial, my lord, of several vital fundamental rights. So in view of IR Polo, I submit, my lord, that needs to be struck down. I'm grateful, my lord.
Thank you, Mr. Dev.
May it please your lordships. Lord, I beg to appear for the applicant in IA 139743 in writ petition 1070 of 2019.
Repeat that, Mr. Giri, the IA number?
Lord, the IA number is 139743. Lord, the All India Kashmiri Samaj
In
in writ petition number 1070 of 2019.
IA is filed which year?
Lord, the IA is 139743 of 2023.
23.
In writ petition number 1070 of 2019. But I'll just
Yes,
Lord, areas which are covered, my Lord, by the learned attorney, the learned solicitor, and thereafter by Mr. Dwivedi, my Lord. Lord, I'll just say what has been covered, and therefore I don't have anything more to say on that. But my Lord, this is essentially my Lord, it's stressing on certain aspects, my Lord, which I think will be of assistance in making out a case before your lordships. My Lords, the instrument of accession, my Lord, is dated 27/10/1947. And that is at PDF 9 of Volume 1. My Lords, what happened in the thereafter, my Lords, in chronological order, I'll be obliged if your Lordships kindly have a look at the proclamation issued by the Yuvraj Karan Singh in Volume 3 of the written submissions, the compilation of written submissions of the respondents at PDF page 44, part of the list of dates, my Lord, of the learned solicitor. Page 44.
Of volume?
My Lord, of Volume 3, the same volume which was being referred to by. Because clause 7 and 8 of the instrument of accession was being relied on to contend for the position that there was a vestige of sovereignty which was retained by the Yuvraj even then, even after signing the instrument of accession, because that is what is articulated in the instrument of accession as such. My Lord, on 25/11/1949, the draft constitution was ready. And therefore, my Lords, the Yuvraj Karan Singh had the entirety of the constitution, including 370 as it was incorporated in the constitution before. Article 1 and 370, my Lord, which is incorporated, which is made as part of the constitution, or which is made as part of the applicability of which was made as part of Article 370. All this was before him. And therefore, my Lord, on 25/11/1949, if your Lordships have a look at PDF 44, Yuvraj Karan Singh issued my Lord, I'm reading from the solicitor's list of dates, issued a proclamation for the state of Jammu and Kashmir by which he declared and directed that the Constitution of India shortly to be adopted by the Constituent Assembly of India.
So, Giri, you are at PDF page 54.
No, PDF page 44.
44.
Written submissions, volume 3. My Lord,
Yes,
part of the list of dates that was placed before your Lordships by the learned solicitor. My Lord, the document is also included, but I thought this is easier, my Lord, because your Lordships will have to keep referring to it again and again. The said proclamation is both worth quoting in full. Sorry.
Yes, I get it. Yes.
Whereas with the inauguration of the new constitution for the whole of India now being framed by the Constituent Assembly of India, the Government of India Act 1935, which now governs the constitutional relationship between this state and the Dominion of India, will stand repealed. And whereas in the best interest of this state, which is closely linked with the rest of India by a community of interest in the economic, political, and other fields, it is desirable that the constitutional relationship established between the state and the Dominion of India should be continued as between the state and the contemplated Union of India, and the Constitution of India as drafted by the Constituent Assembly of India, which includes duly appointed representatives of this state, provides a suitable basis for doing so. I now hereby declare and direct that the Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, insofar as it is applicable to the state of Jammu and Kashmir, govern the constitutional relationship between this state and the contemplated Union of India, and shall be enforced in this state by me, my heirs and successors, in accordance with the tenor of its provisions, that the provisions of the said Constitution shall, as from the date of its commencement, supersede and abrogate all of the constitutional provisions inconsistent therewith which are at present in force in the state. So, my lords, therefore, it was understood that on the enforcement of the Constitution of India, my lord, which took place on 26/1/1950, there is no residuary sovereignty that is retained, my lord, by the Yuvaraj in the state of Jammu and Kashmir. My lord, the territories comprised within the state are therefore mentioned in the Constitution. It is treated as a Part B state. The provisions of the Constitution are made applicable to the Union of India, including the state of Jammu and Kashmir, with effect from the date of enforcement, that is, my lord, on 26/1/1950, when the Constitution commences. It is, my lord, difficult to countenance an argument, my lord, this I say so with greatest respect, that there was any sovereignty which, whether you call it as residuary, internal, as distinguished from external sovereignty, which survives, my lords, the enforcement of the Constitution of India with effect from 26/1/1950, when, after, my lord, the Yuvaraj had also made it clear and had declared that the relationship between the state and the union will now be governed by the provisions of the Indian Constitution, which means that we don't have anything more. We are governed by the Constitution of India. We have also looked into it. There were 4 representatives from the state of Jammu and Kashmir earlier in the Constituent Assembly. We have gone through each clause, and we have ultimately looked at 370 also, which is an integral part of the Constitution, which is also a part of the Constitution. And we have therefore decided that we will abide by this. Now, my lords, the question of if this is the integration, therefore becomes complete, my lord, on enforcement of the Constitution, there is nothing residuary about. Now, if your lordships kindly have a look at, my lord, I'm sorry, but then to make my submission, my lord, on the question of, my lord, what therefore survives under what therefore survives, my lord, will also have to be looked into in Article 370 and 373, and there is nothing more, my lord, which can be read into it. There is nothing in the Constitution of India, my lord, which carves out an exception in the case of state of Jammu and Kashmir, both as regards the sovereignty, any sovereignty, other than, my lord, Article 370 itself. And 370, in my respectful submission, does not indicate that there is any residuary sovereignty that is left with the state of Jammu and Kashmir. It becomes a part of the Union of India. My lord, the enforcement of Article 370 also, and powers exercised by the President from time to time in issuing a constitutional order, is also an exercise of a power that is conferred, my lord, under the Constitution of India. It is nowhere else. President doesn't go outside the bounds of the Constitution. And therefore, my lord, if abrogation of 370, which would result, my lord, in the effacement of any special status that is given to the state of Jammu and Kashmir, is inbuilt into Article 370, and it is also within the knowledge of, my lord, the sovereign in the state of Jammu and Kashmir, my lord, prior to the enforcement of the Constitution, to say that I still retain some residuary sovereignty with me in spite of the enforcement of the Constitution after 26/1/1950, not reflected in Article 370, not reflected in any other provision of the Constitution of India. My lord, it's not a submission that would be countenanced by your lordships. But what are the petitioners asking for? Petitioners, my lord, say that 370, which is a temporary provision, must be treated as a permanent part of the Constitution. What form? If, my lords, is it for the purpose of, my lord, claiming for expansion of any right? Apparently not. No, my lord, because once the 370 goes, and, my lord, Jammu and Kashmir, my lord, therefore, the integration is complete even when the enforcement of the Constitution takes place. My lord, the insignia of any sovereignty is a lawmaking power. One of the insignia is a lawmaking power. That's, my lord, the lawmaking power, my lord, has been with the union and with the states, my lord, in list 2 and list 3 also. Unless, my lord, the parliament by an overarching by resort to the provisions, my lord, of lawmaking power in the list 3 also, supersedes the legislation that is prevailing in the state. If, my lord, it completely therefore applies after Article 370 is abrogated, isn't there an expansion of the right, my lord, that is available to any person who says that I am a resident in the state of Jammu and Kashmir? I therefore belong to that state. I also belong to the Union of India. But therefore, my lord, what is the abridgment of the right, my lord, that the petitioners are really concerned about? No, my lords, insofar as abrogation of 370 is concerned, when the lordships would have noted that sub-article 3 was also therefore part of, my lord, in the manner in which it was framed even before 1950. I mean, on 26/1/1950, my lord, this is how it looked at. And that was at a point of time when the Constituent Assembly for the state was yet to be convened. It was convened later, my lord, in January 1951. Now, if your lordships kindly come to that for a moment. There are two places, my lord, where the Constituent Assembly for the state is referred to. Firstly, my lord, in sub-article 2, but please come to sub-article 3. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. My lord, the crucial words are recommendation of the Constituent Assembly of the state referred to in clause 2. My lord, in clause 2, the reference to the Constituent Assembly is qualified by certain words, my lord. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or the second proviso to subclause D of that clause be given before the Constituent Assembly, my lord, please permit me to read it slowly, for the purpose of framing the constitution of the state is convened. Therefore, my lord, it was understood that a Constituent Assembly will be convened for the purpose of framing the Constitution of India as originally contemplated in Article 370 itself. But this Constituent Assembly is only for the purpose of framing the Constitution of the state. And, my lord, it is a fact which is accomplished that on framing the Constitution for the state, my lord, it dissolved itself. That it will be convened for a specific purpose and that it will dissolve itself were also matters within the knowledge of the framers of the Constitution even then. And then, my lord, therefore, in proviso, when they refer to the Constituent Assembly for the state, there was a terminus acco, my lord, for the Constituent Assembly, which was within the knowledge, my lord, of the framers, and therefore that is what is referred to in the proviso. My lord, it could not have been contemplated that the Constituent, it was, or rather, my lord, let me put it this way. It was, my lord, it was concluded, or it was definitely, my lord, the intention that the Constituent Assembly for the state, which is convened for the purpose of framing the Constitution of the state, will have a natural death, my lord, when the Constitution for the state is framed. But when they say, my lord, that the recommendation of the Constituent Assembly for the state shall be necessary before the President issues such a notification, did they not have in mind that the recommendatory powers are therefore coterminous with the tenure of the Constituent Assembly, which has to end, my lord, with the framing of the Constitution for the state? It is not as if, my lord, the Constitution contemplates a Constituent Assembly for any purpose other than the framing of the Constitution for the state as such. Therefore, my lord, see, one of the termini which your lordships were referring to, there are two terminus acco, my lord, insofar as the Constituent Assembly is concerned, going by sub-article 2 and the proviso. One is the convening of the Constituent Assembly, and the other is the dissolution of the Constituent Assembly. The proviso merely does not say Constituent Assembly of the state. It says Constituent Assembly of the state referred to in clause 2.
Clause 2 says Constituent Assembly for the purpose of framing the Constitution. Therefore, the tenure of the Constituent Assembly is inbuilt, my lord, into sub-article 2 and the proviso as well. If therefore, my lord, the triggering factor as per the proviso to Article 373 for the President to issue a public notification either abrogating it or, my lord, declaring that it will be operative only with such exceptions and modifications is a recommendation of the Constituent Assembly of the state referred to in clause 2. It has to be inferred, in my respectful submission, that the triggering factor would be alive and operative only till such time as the Constituent Assembly is alive. And this is an inference, my lord, which I beg to infer and which I commend for your lordship's acceptance. Is inbuilt into sub-article 2 and the proviso. That's why, my lord, the crucial words Constituent Assembly of the state referred to in clause 2 need not have been that way. But when sub-article 2 says before the Constituent Assembly for the purpose of framing the Constitution of India, therefore, my lord, even originally it was contemplated that this Constituent Assembly for the state will have no function other than, my lord, or will be functus officio once the Constituent Assembly of the Constitution of the state is convened. That, my lord, it's a historically recognized fact that it actually dissolved itself in 1957 itself. But that's a different matter. But the point is, my lord, for the purpose of the proviso, the triggering factor, my lord, is contemplated as being available coterminous with the life of the Constituent Assembly referred to in sub-article 2, and therefore, my lord, it ceases to have any significance, my lord, once the Constituent Assembly is dissolved and once the Constitution of the state is formed. But, my lord, it cannot, under any interpretative tool, give fodder to a submission that Article 370 as a whole, and at any rate Article 370 sub-article 3, would also cease to be operative once a proviso becomes inoperative. My lord, ideally, my lord, the proviso could have been deleted after the dissolution of the Constituent Assembly for the state. That's a different matter, my lord. One need not get into that hypothesis at all. But it cannot be contended that the power of the President vouchsafed under Article 373 would cease to be available because the proviso is no longer available to be operated upon. In my respectful submission, the proviso itself contemplates that the recommendatory power of the Constituent Assembly, my lord, whatever is the content of the recommendatory power or not, my lord, it's a different matter. I think enough submissions have been made on that. But the recommendatory power of the Constituent Assembly was intended even originally to be coterminous with the life of the Constituent Assembly, which anyway, my lord, was dissolved after the Constitution of the state was convened. My lord, my written submissions are at pages 400 to 411, my lord, of volume 3. 401 to 411 of volume 3.
411 to
401 to 411. My lord, this aspect has been dealt with, my lord. I won't therefore take up more time of your lordships on this aspect.
My lord, paragraphs 1 to 4 I have dealt with this. My lord, the next submission, my lord, would be on the aspect of federalism. My lord, there are two, my lord, papers, my lord, which your lordships may kindly have a look at, juxtaposed with each other. My lord, one is the opening remarks of Dr. Ambedkar, my lord, which your lordships will find in volume 8 of the compilation of documents.
Okay,
Sorry.
since you're beginning a new point on federalism, should we take it up on Monday?
Very well.
So that,
Very well. Lord, I'll still maintain the timeline.
we are always conscious of how you are generally in the court, so we don't expect anything different. You'll be precise and always very,
grateful.
very focused. We
I'm
expect that as usual.
I'm grateful.
Thank you.
My lord, there was one request, my lord, lordship, if your lordships could consider, because it fell from your lordships, my lord, would it be possible for your lordships to convene at 10 o'clock on Monday so that we get 3 hours?
Lord, Mr. Nataraj had, my lord, 10 minutes of submissions. A new point.
The circumstance for today, we have given you full half day now.
Very good.
You've
Lord,
got a half day more.
No, Mr. Nataraj would like to have 10 minutes and two young, two other, my lord, people who will, I know your lordship would not.
We'll come back.
Then
All
Mr.
young, not so young can divide the time period between 10:30 to 1 o'clock.
10:31. At the same time, I know that everybody has worked very hard. We wouldn't want to
Therefore, my lord,
deprive
and
even
some
at
of
least
them
5
have-
minutes of time.
Lord,
to the
some
young
of them
people.
have worked since 10 years. Let them have, my lord, their day in the court, my lord,
You're
maybe
saying-
for some time.
I'm sure that the seniors who precede them will give them some time so that they have that
No,
time.
we'll do
to-
that.
Certainly.
For example, my lord, Mr. Tanwani is also a research scholar.
Who?
Mr. Tanwani, Mr. Rahul Tanwani has been spending.
Tanwani, Mr. Rajput, they have been working since many years.
Will certainly give
But
them.
whatever
some
they
time.
can contribute.
Told Mr. Tanwani that some of the points I wanted to make, I will keep for him.
I'm sure you'll be able to.
We'll do that.
It's a-
We'll do. We won't exceed the time. We'll finish by Monday, 1 o'clock or whatever is the time that your lordships are.
1 o'clock.
So we'll wrap it up on Monday for this side at 1 o'clock. And then in the afternoon, we'll start the rejoinder.
Very good.
Grateful.
Grateful to you.